Ladies and gentlemen, welcome to the State of our Constitution. I'm John Hood, the president of the John Locke Foundation, one of the organizations that is hosting today's event here at the historic Chowan County Courthouse. This is an excellent setting for the conversation we will have today. This is as I understand it, the oldest government building in North Carolina. It is the oldest courthouse that is still operating in the entire North American continent. And this is the site, the original site of the colonial capital of North Carolina, the Capitol building. Our conversation today with four distinguished panelists will be devoted to the issue of taxes and is the first of three State of Our Constitution series that we're going to be having throughout 2009, broadcasting on Carolina Journal Television. I'll introduce our panelists in just a moment, but first let me take this opportunity to recognize and thank our partners in this important project. The John Locke Foundation and our North Carolina History Project are co-hosting the State of Our Constitution series with the North Carolina Institute for Constitutional Law. Special thanks are due to our many supporters for the project, including Jean Boyce, Mr. and Mrs. Charles Carter, Mark McNeely, Michael Munger, the Honorable Rusty Duke, the Honorable John Tyson, Ruthie Harrell, Bob Steinberg, George Stevens, the Duplin Winery, Stop NC Annexation, and the Fair Annexation Coalition. Thanks also to those of you who are attending here tonight in Edenton and to those of you watching us at home. We think you will find our discussion of the North Carolina Constitution and the power to tax to be lively, timely, and informative. We have an expert panel of attorneys and scholars to discuss these issues, so let me introduce them to you now. Starting right here on my left, Jean Boyce. Jean is a Raleigh attorney and a well-known champion of the constitutional rights of North Carolinians, helping to recover more than $1.6 billion in taxes illegally imposed on North Carolina taxpayers. Next is Jeff Broadwater. He's a professor of history at Barton College. Among his many published works in these areas is the highly praised book, George Mason, Forgotten Founder. Next, John Dinan. He's an associate professor of political science at Wake Forest University and the author of numerous publications on constitutional history, theory, and practice. Among his responsibilities is to prepare the annual entry on state constitutional developments for the influential Book of the States, published by the Council of State Governments. Finally, Bob Orr. Bob is the director of the North Carolina Institute for Constitutional Law. He previously served 10 years on the North Carolina Supreme Court and 8 years on the North Carolina Court of Appeals. Our topic again is the North Carolina Constitution and the power to tax. In the present moment, governments at all levels are facing massive budget deficits. There are large bonded debts, unfunded liabilities, and numerous other fiscal challenges that are of great concern to many taxpayers. Indeed, some have converted their concern into action using historical allusions and even tea bags to connect today's controversies to the tax disputes of the past. North Carolina's rich tradition of debating and sometimes passionately challenging the power to tax extends far back to the founding of our colony. Consider the example of Culpeper's Rebellion. This began in 1677 in what is now Pasquotank County, and it was really a popular revolt against what the taxpayers perceived as unjust taxes imposed by Parliament in England, including, if you can believe it, a controversial excise tax on tobacco. Where have we heard that before? Later, in 1715, the issue was the taxation of land. And again, North Carolina taxpayers rebelled against what they perceived as an encroachment on their liberties by Parliament. Perhaps most famously in 1774, Penelope Barker, Elizabeth King, and dozens of other leading ladies staged the Edenton Tea Party, the first known example of organized political activism by American women. Another of Edenton's famous residents, James Iredell, helped to lead the fight for the ratification of the U.S. Constitution, and he later served on the U.S. Supreme Court. He wrote the following: "The noblest of all causes is the struggle for freedom." And so it is. But enough preface, let's get down to business. Let's begin with this question, which I will direct to Professor Broadwater. North Carolinians have adopted 3 state constitutions: in 1776, in 1868, and in 1971. And that first constitution was also significantly rewritten in 1835. So we have 4 different moments in time. What can you tell us about the issues and the personalities that define these very different moments in our history?
Well, the 1776 Constitution was a product of the American Revolution. It reflected a fear of executive power, among other things. The 1835 amendments come during the age of Andrew Jackson, when American politics are becoming more democratic. Those amendments reflect those trends. The 1868 Constitution was a product of the period of Reconstruction. It was a constitution the state was really required to adopt in order to be readmitted into the Union. It's a little harder to label the 1971 Constitution, but you might say that it was a product of a period in which state governments were trying to become more modern and more efficient. State governments had grown since World War II. North Carolina had over 300 separate state agencies by the late 1960s. And I think that was an attempt, the 1971 Constitution was an attempt to improve public administration. Now, whether it did it or not is another question.
How about giving us a little bit more details about the 1835 rewrite? Wasn't there a lot of sectional strife at the time between eastern North Carolina and western North Carolina?
It was, and that reflected it's really related to the democratic trends of the period. The 1776 Constitution really left eastern North Carolina overrepresented. Representation in the lower house of the Assembly, what they call the House of Commons then, was not based on population. By the 1830s, the majority of North Carolinians lived in the western part of the state. So there was great demand for constitutional reform from the western part of the state. And one of the most important reforms that come out of the 1835 amendments was to expand the House of Commons, it became the House of Representatives, to better represent western North Carolina.
Professor John Dinan, as we're talking about these different constitutions, how did the duties and the powers of the governor and other state officials change during these various iterations of constitutional drafting?
Well, they changed significantly. Let's think about the governor in particular. Originally, the governor was chosen by the legislature for a 1-year term. It wasn't until 1835 that the people got a chance to elect the governor themselves, and they also gave the governor a 2-year term. It wasn't until 1868 that the governor gets a 4-year term the governors currently enjoy. It wasn't until 1977, though, that the governors got a renewable, possibly 4-year term. And it wasn't until very recently, 1996, the last by far of any of the 50 states to give the governor of North Carolina the veto power. So significant changes, and you can pinpoint those at each step along the way.
Would it be fair to say that North Carolina's governor was a relatively weak officer compared to, say, governors in other early states or later states?
That's true, and all governors almost started out very weak. The question is, other states moved their governors to be more powerful more quickly. North Carolina lagged in that regard.
So maybe we were just more suspicious of our governors.
Very much. Very much.
Turned out that was all wrong. We should never have been suspicious. Justice Orr, I understand that you have recently spent some time looking at that 1971 constitutional process. What were the drafters of that final constitution, the one we're living under now, what were they trying to accomplish?
Well, John, before I answer your question, I warned you that I was going to throw out one kernel of historical research that I've come up with, and it came to my attention in Hugh Leffler's History of North Carolina that on July 21st, 1669, there was a predecessor constitution called the Fundamental Constitution, which was a new document prepared for the government of Carolina to promote settlement and to protect property rights. And it was called the first instrument ever digested and written out for the entire and perfect government of a political body. And confirmed by our historians here, it was supposedly written by John Locke. So we have a great tradition
But that was a
to
colonial
be here.
constitution, not a state constitution.
Oh, well, correct, but that sort of set the model for constitutions. The 1971 Constitution actually was a modernization and rewrite of the 1868 Constitution and subsequent amendments. It's technically not a new Constitution, although we refer to it as one of the three that the state has. The other point I'd like to make, though, is that the state Constitution is inherently a limitation upon the power of government. And if you put it in historical context of 1776, what were the framers of that early Constitution trying to do as they established a new government? And that was to put some type of limitation upon that power, and that was certainly true in the field of taxation.
Well, when we talk about constitutions in history, sometimes you hear modern-day politicians or commentators will say, well, why do those issues or disputes have any relevance to us? Indeed, what difference does it make that these issues were debated in our constitutional past? They don't have any relevance. Gene Boyce, I take it you don't agree with that sentiment.
No, I don't. One thing that always comes to my mind is the state of North Carolina had a constitution 13 years before the federal government had its constitution with its grant of powers. And the main thing is to understand what a constitution is for. It serves a twofold purpose. Number one, it sets up our form of government to which we relinquish authority. Number two, it protects our individual rights. The importance of those I gave you in reverse order. The fact that it protects your rights is the most important thing that our Constitution provides. We have given our government limited powers. It's up to you and up to me and up to all of us to get working together to make sure those limits are carried out.
Professor Dinan.
I would just say that the North Carolina Constitution is of very continuing importance because a number of the problems or concerns that people have about North Carolina politics stem from the design of the North Carolina Constitution or would require changes to the North Carolina Constitution to change. If you're unhappy about the legislature engaging in such a lengthy session seemingly every year, one way to change that would be to adopt a constitutional amendment, as many states do, limiting session length. If you're tired of or think it's a problem to have so many council of state elections, North Carolina has one of the most number of them. Georgia has 13. We don't have 13. If you think that that's a concern, one way to change that, really the way to change that, would be to adopt a constitutional amendment. I could go on, but I think I've given the point that if you're concerned about parts of North Carolina politics, one avenue for change would have to be through the North Carolina Constitution.
Well, speaking as a resident of Raleigh, I'm in favor of both of those changes. Fewer people being elected to come to Raleigh, and they shouldn't stay so long. Let's zero in on the specific issue of taxation. Just about everyone would agree that North Carolina governments must have the power to raise sufficient revenue to pay for government responsibilities. That's what taxation is for. But once you start defining these terms, the agreement becomes argument. Professor Dinan, could you outline some of the basic fiscal principles and powers that are set out in the state constitution?
Let me hit some of the highlights. Let me start with the Declaration of Rights of North Carolina. Two key principles: no taxation without representation, without the consent of the people or their representatives. Second key principle in the Declaration of Rights, and that is no taxes can be increased retrospectively. Two key principles. Well, some other key highlights. According to the body of the Constitution, all tax bills must be read in the legislature on 3 separate days. So special is the act of taxation that they set up a special procedural requirement. And all tax bills must state the special object to which the tax is being applied, and it shall be applied to no other purpose. I could mention a few other highlights, and just to skim a few of them, the individual income tax by the Constitution may never exceed 10%. It's in the Constitution. No poll or head tax may be applied. The taxing power may be only applied for public purposes. And a final one I'll mention, all property taxes shall be levied by uniform rule, with some exceptions for local governments.
Well, those are a lot of rules. So, I mean, and we're going to talk about some of those in particular a little later, but it's worth exploring first why there are so many rules. Professor Broadwater, let's try to get into the heads of the drafters of such constitutional provisions. Why are they so intent on, for example, prohibiting retroactive taxation or making tax bills harder to pass than other bills? Why is the special attention paid to taxation?
Well, one reason that taxes were a particularly sensitive issue in colonial America and in early American history is there was a chronic shortage of currency throughout the country. And so even a fairly modest tax in the 1700s, early 1800s could be very burdensome. They didn't like taxes any more than we do, but any tax could be very burdensome to folks in that period.
So we hear today, I was just remembering during the coverage of the Tea Party protests last week, there was some reference to the fact that back in colonial days, these taxes were so tiny. Why were people so upset about relatively tiny taxes back then compared to the huge taxes we pay today? And one of them would just be that cash or specie was so rare.
And that wasn't simply the case with poor farmers or on the frontier, but you will see in the papers of affluent people like Thomas Jefferson or George Washington or George Mason, that at any given moment they may not be able to scrape together a few pounds.
Of course, beyond simply the difficulty of getting coins or the imposition of a tax, whether there be the principle of the thing. Who's making the decision? Is the decision fair?
Yeah. And you see that in the federal Constitution, that tax legislation is supposed to originate in the House of Representatives on the theory that the House is closer to the people than the Senate is. So I think that's an illustration of their sensitivity to the tax issue.
Justice Orr, you've been on the court, as I said, for 18 years. You spent a lot of time tasked with the responsibility of closely reading these constitutional provisions about taxes, listening to advocates on both sides of a particular dispute, and then issuing a ruling. How do you go about turning this general constitutional language into a finding of law?
Well, let me begin by saying that in the 10 years that I spent on the state Supreme Court, virtually every one of the most important cases we decided had a state constitutional component to it. So your earlier question about the relevance and importance of the state constitution was really brought home in my 10 years on the court, whether it was redistricting, whether it was incentives, whether it was Leandro and public education, the tax issues that Gene litigated, all hinged on interpreting state constitutional provisions. And consistently the courts have said you go back and look at the intent of the framers of that constitutional provision. So you have to go back and decide and determine, was it in the 1776 Constitution? Was it in the 1868 version? And so you look at that, you look at a variety of other precedents that the court has decided. If it's within the Declaration of Rights, equal protection, for example, you might look at how the federal Constitution has been interpreted. But you look at a range of these factors when you interpret the state Constitution.
You say that you would look at, for example, which constitutional moment were these words written. Why would that matter? I mean, what does it matter to you whether it was written in 1776 or 1868?
Well, you're looking for the intent of the framers to get an understanding what this general language means. And while there have certainly been some decisions, some of which I haven't agreed with, in which the court has taken a more living document approach to interpreting it, consistently, I believe, and I think most of the court decisions have tried to go back, look at the history of the time, look at the purpose that the constitutional provision was inserted for. And I think we'll talk a little more about public purpose, but it's a wonderful example that begins in 1776, it's carried through to today, and the whole concept is that government, in taking your money in the form of taxation, can only do it for a public purpose and can only spend that money for a public purpose. And the question then is, what's a public purpose?
Well, let's talk about a particular case in which North Carolina courts were confronted with a constitutional challenge to the state's power to tax. This was a federal challenge, but it had to do with the taxation of intangibles. Gene Boyce, you were attorney for the plaintiffs in that case. What were the issues involved?
Well, let me start off with giving one basic proposition, and it goes back not to any written law, but to natural law. Your property belongs to you. There's no question about that. In giving a constitution, in creating a constitutional government and giving power to your government, limited power, you're given two powers. The power to condemn your property for a public purpose, to build a public building, to build a school, to do something for the common good. The second way the government that we have given the government the right to confiscate our property, your property, is taxation. Those are the only two ways. The government can tax almost anything. The poll tax has been nullified by the Constitution. A tax on an individual just being an individual is no longer constitutional. The people, you have decided that. Other than that, most anything is taxable as long as the scheme or the manner of taxation complies with all of the other provisions of the Constitution. You might be interested in knowing that the section on taxation on finance is the longest of all the 14 sections of the North Carolina Constitution. It is meaningful. It is a grant of power, and we must keep an eye on the exercise of that power. In the case that John referred to, the state of North Carolina instituted a double taxation. Corporations pay taxes, and then the state of North Carolina imposed a tax on the stock, dividends from stock in that corporation, taxing the income twice. That provision applied only to out-of-state corporations, the North Carolina intangibles tax. That was a violation of the federal Constitution, which protects interstate commerce. It is important for states to cooperate and not impose restrictions on each other. That case started in 1992. The trial court ruled for the taxpayer. A single taxpayer, you could be a single taxpayer, proceeded to institute that suit and carried it through. He lost in the trial court. He won in the Court of Appeals. He lost in the North Carolina Supreme Court. He then won in the U.S. Supreme Court. It then came back to the North Carolina Supreme Court. It then went to the legislature. And after 7 years of litigation, that single taxpayer upheld the rights of himself and hundreds of thousands of other people similarly situated. That's what you've got to remember. You could do the same thing, because when the Constitution applies to everybody, not just to that one taxpayer, but to everybody. And lawyers don't bring cases, clients bring cases. Lawyers represent the clients.
It sounds like in that example, and I understand in a number of others, that taxpayers can prevail. They can stand up for their rights, but they have to be patient. They have to be willing to persevere through adverse rulings, lots of time. Even once you get a favorable ruling by a court, you may not get the legislature to immediately comply.
Persistence pays off. If you don't ever give up, you don't ever lose. It's as simple as that.
Justice Orr.
While this isn't directly on taxation, Gene participated and is continuing to participate in a case involving the Highway Trust Fund that was originally dismissed on the grounds that a taxpayer had no standing or right to challenge an alleged unconstitutional expenditure by government. And fortunately, as Gene has indicated, this case went to the state Supreme Court and received a favorable ruling, so that now finally it's clear taxpayers do have the right to challenge an unconstitutional expenditure.
Let's stay on the topic of particular constitutional disputes about taxes, but let's talk about some additional ones. In recent years, taxpayers have brought a number of lawsuits on tax issues to the courts. For example, taxation of government pensions, the inviolability of government trust funds, as Bob just alluded to, the enactment of the state lottery, a number of others. Justice Orr, you have a particular interest in the issue of governments giving targeted tax incentives to corporations intended to encourage them to expand or locate in North Carolina. Why are you so interested in that particular topic?
Well, I'm particularly interested because I think the Supreme Court erroneously interpreted that critical clause in our Constitution that I alluded to earlier, that you only tax people for a public purpose and you only spend that money for a public purpose. And I think we all understand historically schools, roads, those were the kinds of public purposes that your money was, your tax dollars were used for. Unfortunately, beginning in the 1980s, we saw a practice nationally and in North Carolina where government would take tax revenue and give it to an individual corporation, many times in the millions or hundreds of millions of dollars, in order to locate a factory or a company or to expand. And an issue came before the Supreme Court, is that a public purpose? Historically, our court had answered no. You do not use the public's money to subsidize or support private entities. Unfortunately, in the Moretti decision, the Supreme Court, with Justice Lake and me dissenting, reversed that whole concept and said, well, if it creates jobs, if it's for economic development, then therefore it's a public purpose and they can spend however much of your money for Dell or Google or whomever.
I can't imagine why big bailouts of corporations would be unpopular.
It's a way of life.
Yeah, but this issue of the public purpose is interesting because there seems to be an attempt to redefine that as from public purpose to public use, then to a private use that could be conceived as benefiting the public in some way. I mean, you said that the previous decisions by the courts in the past had a more narrow view of this provision. Why was it broadened?
Well, you had a taxpayer, actually Bill Moretti, a lawyer in Winston-Salem, was fed up with seeing large amounts of revenue, public revenue, going to various individual corporations. So he brought the challenge. The trial court, Judge Rousseau, said it's clearly unconstitutional. Unfortunately, when he got to the state Supreme Court, a philosophy of, well, times have changed, so therefore the meaning of the Constitution must change, prevailed. I think it's fundamentally wrong. I'll quote Sam Ervin, an issue isn't properly decided until it's decided correctly, and I think that's still one that needs to be decided correctly. At this point, there are no parameters on public purpose. If a company says, we'll move to Edenton if you'll provide 3 yachts and a country club membership to our executives with public money, under the current state of the law, that's a public purpose. I fundamentally disagree.
Just to be clear, since we have the mayor of Edenton here, that is not a real example. That is not currently being negotiated. Professor Dinan, let's talk about another example that's interesting, and that is the case that Bob was involved in, representing plaintiffs challenging the constitutionality of how North Carolina came to have a state lottery. Why was that a tax issue? What is the underlying issue there?
Well, you'll recall the provision that we discussed earlier. If you pass a tax bill must be read on 3 separate days in the legislature. Well, there was no disputing the lottery passed without being read on 3 separate days. The question before the courts was whether the lottery was a tax bill that fell under that provision. The North Carolina Court of Appeals ruled it was not such a bill, and therefore the lottery was legitimate. When it came to the North Carolina Supreme Court, the North Carolina Supreme Court split 3-3 with one recusal, therefore allowing the appeals court decision to be upheld and the lottery to continue. I should say that the lottery has been a source of one other concern, and that is with the governor's recent announcement of the diversion of lottery revenue to non-education purposes. That has given renewed momentum to those who would seek a constitutional amendment that would so prohibit the diversion of funds. I should say that the state of Virginia faced a similar situation and 9 years ago passed such a constitutional amendment to their lottery. No lottery revenues shall be diverted to non-education purposes.
Is there a problem right now, the way our Constitution exists right now, with does the Constitution prohibit or arguably prohibit lottery revenue from being spent for some purpose other than education as originally advertised?
Arguments might be made that along those lines that the way the statute is written now, it's written on a statutory grounds. There is no explicit constitutional prohibition, although one might argue that there could be read one into the Constitution. Virginia, as I say, actually passed an explicit amendment. No more. North Carolina could clearly do so.
Bob, is there such an argument?
Well, what I was going to say was, I wasn't going to address that, John. It was, there was an underlying issue in the lottery case as to what is a tax. We've heard from the other panelists about the various limitations on the General Assembly when it comes to taxation. But if they impose a fee or something else and don't call it a tax, can they avoid those limitations? And so the underlying issue in the lottery case was, is that 35% in each dollar of lottery revenue that was supposed to go to public education, was that in essence a tax and therefore had to comply with the various provisions? And that question is still floating out there. Maybe Gene or somebody else will be litigating it. What is the definition of a tax for purposes of the state constitution?
Well, I presume that one distinction between a tax and a fee would be the fee is something you pay to obtain a particular service, get a permit, have something in particular given to you as a government service in response for paying that fee, as opposed to a tax which does not have that direct relationship. Right, Gene?
Correct. The Constitution is but a set of words, phrases, clauses, and sentences. I'll give you one illustration. In the retrospective tax case, the case turned erroneously by the Supreme Court in that it did not pay attention to a document from the 1868 convention that clearly showed that the word transaction was stricken and the word acts was put in its place. I don't have time to tell you how important that was. Transaction has a business connotation. Acts is broad. It would cover anything. It would cover labor. The Constitution, the proposal was written, sales, purchases, and other transactions. The word transactions was converted to acts. That made the difference that you cannot imagine, because acts included labor, and there cannot be retrospective tax on acts and on labor, which is translated to income. That's how important
and this goes to the point that was made earlier about when you're trying to interpret these constitutional provisions and apply them to a particular dispute, you have to get in the heads, you have to look at the information you have about why the particular language was written when it was written.
History has a lot to do with it. I learned in law school, my professor said the first week, if you don't know the reason for the law, you'll never understand the law. And that is meaningful. History means a lot and the reason for having a law, the reason for having a constitutional provision is a controlling factor. And words are to be given their common understanding, words that you and I mean, not words that politicians and meanings that politicians want to give.
Well, I appreciate the segue, because I was about to ask our historian a question which has to do with this general, we just talked about a few examples of disputes, the state lottery, tax incentives, retroactive taxation. is striking to me and other laymen just how often political issues become, particularly issues involving taxation, become legal and constitutional issues before the courts. Is this something that you think is truly new, or is this something that the framers of our state and federal constitutions would see as routine?
Well, I mean, it's true we're more litigious today than we were 100 years ago or 200 years ago, but tax litigation is nothing new. One of the very first cases that went to the Supreme Court in the 1790s was a lawsuit challenging a federal tax on carriages. I believe it's Article 1, Section 2, prohibits direct taxes unless they're apportioned by population, and there was an argument this was a direct tax. The court ruled that it wasn't a direct tax. But my point is that this kind of litigation goes back to the 1790s. And to follow up on a point that Gene made, the quote that I remember is from Oliver Wendell Holmes, and I think I can remember this correctly: a page of experience is worth a volume of logic. I think that was his way of emphasizing the importance of history in interpreting the Constitution and deciding cases.
Well, we've talked about a few specific flashpoints of this applying the Constitution to the power of taxation, but let's put it in context a little bit and talk about North Carolina's Constitution in comparison to other constitutions, and try to learn a little bit more about how much or how little North Carolina restricts the power of taxation. Gene Boyce, let's start with you. In your opinion, what are the key differences between the federal Constitution and the state Constitution when it comes to the power of taxation? From the standpoint of protecting taxpayers, is one superior to the other?
Well, in my judgment, the North Carolina Constitution is superior. It is different. It gives greater rights. It protects more property, and that is what your tax money is, property. For example, as I think the professor has already mentioned, North Carolina has a provision which says your income tax rate cannot exceed 10%. That is a constitutional cap on income tax. I wish the federal Constitution had some kind of limit on tax. You remember, those of us who have some memory of World War II, it got to 94%. In the 80s, in the Carter administration, 91%. They're talking about now, I think it's 35%, they're talking about maybe raising it up. The federal Constitution has no limit on taxation. Another important feature of your Constitution is that you say the government must operate on a balanced budget. That means not only the state, but cities and towns must operate on a balanced budget. Counties must operate on a balanced budget. It just is common sense. You need to operate on a balanced budget. We all do. So why not government? And in the North Carolina Constitution, although it was a procedure and a policy for many years, that is now specific provision limiting the governor and giving the governor limited authority to balance a budget when the revenues are not sufficient to meet the appropriated expenditures. State law, when you're taxed, your representatives in the legislature have to tell you what the tax is for. They have to spell out a specific purpose. If the government wants your money, they got to tell you why. That makes a lot of sense, doesn't it? It's just plain common sense. And then step 2, in the North Carolina Constitution, the provision was added: the tax law must state a special purpose, and it can be spent for no other object. That only makes sense. It's a promise. You take my money by taxes, you tell me what you're going to spend it for. When I give it to you, you spend it for what you told me you were going to spend it for. And that has been violated in at least 2 cases with which I'm very familiar.
Professor Broadwater, you have studied the founding era. Obviously, you wrote a book about one of the principal figures of early American history, George Mason. Help us understand more about how the framers of the federal Constitution, we talked earlier about the state constitutional rewrites, but what were those framers thinking about when they got together in Philadelphia and drafted the federal Constitution?
I mean, they were sensitive to the issue of taxation, but the federal Constitution says less about taxes than the North Carolina Constitution does, or as it says less than most state constitutions do. And I think there are two reasons for that. One's historical, one's more philosophical or theoretical. We've got to remember that in 1787, when the federal constitution's drafted, we'd had 10 years of experience with the Articles of Confederation, in which Congress had no power to impose taxes. Congress could borrow money, they could ask for money from the states, they had some revenues from the sale of public land, but the problem in 1787 was generating enough revenue for Congress to be able to pay its bills. So you have to put the Philadelphia Convention in that historical context. The other reason I think the federal Constitution has fewer safeguards is more philosophical, and that is that because the federal Constitution is essentially a grant of power, and the framers, and particularly Madison, and I'm working on Madison now, would argue, well, we don't need to put a lot of limitations on the federal government because it hasn't been granted the power to do this or to do that. So there are some fundamental differences between the federal Constitution and the state Constitution to explain really a radically different approach to the issue of taxes.
Well, as I recall it, Alexander Hambleton also argued, perhaps not seriously or perhaps disingenuously, but he argued against specifying a Bill of Rights because his position was that, or in others' position was that if you specified what government couldn't do, that might suggest that anything you didn't prohibit them from doing, they could then do.
Hambleton made that argument. Most of the Federalists made it. Madison made it at one point, and I think later changed his mind. Yes, one argument against the Bill of Rights is, say, if you protect religion and freedom of the press and the right to bear arms and you leave something else out, then the assumption is citizens have surrendered that right. When Madison later shifts his position on the need for a Bill of Rights and introduces one in Congress, he includes what becomes the 9th and 10th Amendments, which are sort of catch-all amendments to reserve to citizens and to the states those rights that are not specifically protected by the first 8 amendments.
So the 9th and 10th Amendments, the 9th saying that just because we specified some rights doesn't mean there aren't others, and the 10th saying that if we didn't specifically delegate powers, then they don't persist in the federal government.
Is trying to draft his way around that concern that we may inadvertently give up some other rights.
I guess some might argue that the 9th and 10th Amendment don't get cited very much.
Well, I mean, they're vague and they're ambiguous, and it is a problem. It's not easy to interpret them.
Justice Orr, I'll come back.
Let us not forget the state constitution. Article 1, Section 36 says, the enumeration of rights in this article shall not be construed to impair or deny others retained by the people. They were going to make sure that they kept whatever rights were inherent in their freedom, and by simply granting specific rights to the government, that in no way impaired or limited the rights that they retained.
And I'm sorry.
Go ahead.
I suspect, I can't prove it at this point, but that language shows up in other state constitutions and declarations of rights, and I suspect Madison probably was borrowing some of the language that he used from some of the state documents.
Boyce.
When you mentioned Alexander Hamilton, it brought to mind something I read last week. He was the first Secretary of the Treasury. That's the last time the United States had a balanced budget. 0 revenue, 0 expenditures.
Did Alexander Hamilton pay his taxes on time? You know what would be really handy? I was seeing Justice Orr reading a particular provision from the state constitution. It would be really handy if someone had copies, like really easy to hand around, keep in your pocket, someone ought to think about doing that. Actually, we're going to give you copies of the Constitution later. Let's talk about another comparison. Professor Dinan, you spend a lot of time comparing the constitutions of the various states. So now we're not looking at federal versus state, but North Carolina versus other states. How does our Constitution stack up when it comes to fiscal issues and other issues?
Well, we've talked up here about a number of protections that taxpayers get in the North Carolina Constitution, but I will say that taxpayers in other states get even more protection depending on their constitution. Let me give some examples. In some state constitutions, if the legislature wants to raise taxes, they have to do so by a supermajority legislative vote, sometimes by a 2/3 vote. Think of how difficult that makes it to raise taxes if you've got to get 2/3 of the legislatures behind that. Colorado, though, they go the farthest of any. 1992, Colorado passed a citizen-initiated Taxpayer Bill of Rights constitutional amendment. Among other things in the Colorado Taxpayer Bill of Rights, any tax increase at the state or local level must be submitted to a popular referendum before it can take effect. It's also the case that Colorado says that spending may only increase each year by a certain amount, determined by a formula. How much has the population increased? What else has taken place in cost of living? That's how much you can spend each year more than you did last year. Colorado goes even further and says, and if more revenue is taken in than that formula allows, the rest of the money refunded to the taxpayers.
Well, the key term, it seems to me, in your explanation was citizen initiative. The Colorado Taxpayer Bill of Rights and even some of those supermajority requirements to raise taxes, I think Arizona and some others, weren't those instigated by citizen-initiated referenda? In other words, how often does a legislature decide, you know what we're going to do? We're going to approve a bill to see if the public wants to limit our power. I mean, they don't typically do that, do they?
Just as few legislators have passed legislative term limits amendments, few legislators have passed these type of amendments. That's a type of provision that gets passed through citizen ballot initiatives of the kind that are found in half of the states but are not found in North Carolina. In North Carolina, the two ways that you can change the Constitution are, one, by the legislature by a 2/3 vote can submit to the people, do you want to call a constitutional convention? That's one mechanism. The other mechanism, the legislature can say by a 3/5 vote, they can submit an amendment to the people for their ratification. North Carolina does not have a citizen initiative procedure, which is one of the reasons why it becomes more difficult to pass some of these provisions that we've mentioned.
I think, Professor, you left out the third way that you could change the Constitution, which is you can be elected to the state Supreme Court and then just rewrite it however you like. Right?
You interpret the Constitution.
Oh, okay. Well, speaking of, Justice Orr, you've not only been on the court, but you've been in the court recently and in the past seeking to apply constitutional language in a particular dispute in which you are an attorney for a plaintiff. But let's appeal not to a particular Supreme Court, but to the court of public opinion. Make your case for any changes you would like to see in the state constitution, particularly when it comes to taxation.
Well, the most important would be defining public purpose. Right now, as I said earlier, it's unlimited. I think a constitutional amendment that would put some limitation, some scope of reference to public purpose, because it's not just in the context of taxation and spending, but also in condemnation. You know, I think we need to make sure that if you're taking a citizen's property, that property's only being taken for a public purpose. And the second one would be in the amendment process. There is a practice in North Carolina. When they submit a constitutional amendment to you, the public, they don't have to accurately reflect what's in that constitutional amendment. And I won't go into Amendment 1, which was a 2004 amendment that took away your right to approve tax increment financing bonds. But if you read the language that was on the ballot, if you look at the actual amendment, even the most astute constitutional scholar could not tell you that you were being asked to give up an existing constitutional right. And that's fundamentally wrong. And I think that would be the second most important area that I would look to amend the Constitution.
Well, actually, I mean, let's underline that example you brought up of tax increment financing. That's another case where the Constitution requires, if a government issues general obligation debt, the voters get to vote on it. This was a case where everybody recognized that issuing these particular kinds of bonds would require a vote, so they went in to change it, and they tried to change it a couple of times and it failed. because it's specified in the ballot, well, you're giving away your right to vote on bonds, right?
Correct. And so the framers of this last constitutional amendment said, well, we'll never get it passed if we're honest with the people about what's at issue here. And unfortunately, they got away with it. Although I confess we have a case currently pending in the Fourth Circuit that hopefully will ultimately lead in Amendment 1 being struck down. But there's a bill dealing with this Superintendent of Public Instruction issue that I'm involved with, in which they want to go to an appointive superintendent. But if you look at the bill, if you pull it up on the legislative website, what's on the ballot does not tell the voters of the state you're being asked to give up your right to elect the Superintendent of Public Instruction. Now, if the public wants to give up that right, that's the public's right. But it's fundamentally wrong not to put that on the ballot and make sure that voters know exactly what is at issue when you're amending your Constitution, which is the one limitation you have on state government.
Well, let's sum up this part of our discussion today with a final question, and that is this. I'll start with you, Gene. Why is it important for North Carolinians to know about their state constitution? What difference does it make?
Well, it is your law. It is your law. It is the people's law. It can be changed only by you. The Prime Minister of England is quoted as saying, precedent embalms principle. Well, your Constitution sets forth a number of principles. Unless you keep an eye on government, unless you keep an eye on the politicians, the precedents that they create can embalm your principles set forth in your Constitution. You have to be on the alert. You have to sacrifice time. You have to be persistent. But it's your law, it's your Constitution, and it's up to you to see that the people you send to Raleigh, the people you elect to the various governmental offices, do the right thing, use common sense, read language, the English language as it should be read, and that they obey your law. It is really that simple.
Professor Broadwater.
I agree, and I would add two things. Remember that the North Carolina Constitution is longer and more detailed than the federal Constitution, which means really more issues that would come up at the state level are constitutional issues. I mean, the North Carolina Constitution covers a lot of things. It is important. The other point I would make is that although it's not that long, again, it is longer than the federal Constitution, it's not impossible reading, but it's not exactly beach reading. And I think we need to think more about how we teach the North Carolina Constitution and how we educate people as to what's in the Constitution.
High school students in North Carolina are required, in public schools, are required to study North Carolina history, right?
They're required to study North Carolina history. I haven't, and I teach North Carolina history. I haven't seen much evidence that my students are familiar with the North Carolina Constitution. I mean, the North Carolina history is that's a pretty broad topic. That doesn't leave much room for talking about the North Carolina Constitution when you're trying to cover the state's entire history. But I do think we need to think more about how we teach the North Carolina Constitution.
Professor Dinan.
I think people in North Carolina should pay attention to their Constitution in part because constitutions have in other states been a vehicle for significant policy changes and with significant policy consequences. I'll just mention two. One, same-sex marriage has been or soon will be legal in 5 states in the U.S. Massachusetts, Connecticut, California, Iowa, and Vermont. In 4 of those states, that was achieved through interpretation of the state constitution. Vermont is the only state in which it was done through the legislature without a direction of the Supreme Court through an interpretation of the state constitution. In one of those states, though, California, the people responded to the Supreme Court decision by passing a constitutional amendment overturning the Supreme Court and saying same-sex marriage will not be legal in California. 29 other states, including all states in the Southeast, have also passed similar amendments preventing their state Supreme Courts from imposing same-sex marriage. So that's one issue in which, if you look around to other states, you can see that the state constitution has been enormously important. A second issue is the power of eminent domain, the ability of a state, of a legislature, a locality, to take your property and put it to use. They pay you what it was, compensate you for what it was worth, but they take your property. And the question has come up recently, can they take your property not to build a road, not to build a school, but for economic development purposes? A number of states in just the last 2 years have tightened their state constitutions to prohibit use of eminent domain, taking of your property for economic development purposes. Same-sex marriage, eminent domain and private property, crucial policy issues and rights issues that are very much implicated by state constitutions.
Justice Orr.
John, I'll answer with a one-sentence quote from the case of Richmond versus Town of Tarboro, delivered in 1890 by Justice Shepard of the North Carolina Supreme Court, where he said, in the absence of constitutional limitations, there is, it is said, no restraint whatever upon the legislature, and it may discriminate in favor of or against a particular class of persons or property and pass laws in violation of every principle of just government by an unequal distribution of the public burdens. That's why the state constitution is so fundamentally important to you and every one of the citizens in our state.
Ladies and gentlemen, please honor our distinguished panel with a round of applause. On behalf of the John Locke Foundation and the North Carolina Institute for Constitutional Law, I thank you very much for your attendance today.